Good afternoon and welcome everyone to our HR Quarterly Updates webinar. My name is Michelle Maaije and I'm today here together with my colleague Maarten van Kempen.
Good afternoon.
Today we would like to discuss a few topics with you. One of the topics that we will discuss are ESG developments. We will also talk about the 30% tax ruling, some recent changes in legislation, recent court case regarding holidays. Maarten, if you would like to start with the ESG developments.
Thank you so much. ESG development stands, of course, for all kind of sustainable development goals that we are looking into since a few years. In the Netherlands, we have what we call the ESG, which is, of course, for environment, social, and governance. I would like to discuss three different developments which have come to life in 2023 and also to be expected in 2024. One is a social development goal, which is about equal pay, which is of course about gender. Then I would like to talk you through some of the topics of the Dutch Corporate Governance Code, and in the end, of course, some environmental issue, which is the reporting obligations, work-related personal mobility, which is also a reporting issue. Let's start first about equal pay. In 2023, the new Pay Transparency Directive has come to life. It has been adopted by European Parliament, and now it is to be implemented by all European countries in local legislation. So for now, we are awaiting the Dutch legislative initiatives in that. Well, the goal of this Transparency Directive for equal pay is, of course, by getting some transparency and employing effective enforcement measures. And it is to make sure that equal pay, especially when we're talking about men and women, is to be affected. And how are we going to do that? In the first way, this is about reporting. The first thing we have to do, of course, is to report about inequalities. And I'll go through that a little bit later. Member states have until June 2026 to implement this directive into national law, and it is for all sorts of companies, private companies and also public companies. First of all, there will be a reporting obligation. And that means that we have companies which we consider large companies, which are companies with more than 250 employees. We have middle large companies, which means we are companies 150 to 249. And then we have the, let's say, smaller companies, which have 100 to 149 employees. Each company has its own reporting obligations, and the bigger companies, let's say the 250 plus companies, they have, of course, the most foregoing obligation. And of course, they have to put in annually reports to the competent national authority about equalities. We see with the medium companies, which are the 150 to 250 employees, that we are talking about every 3 years conveying such a report. And when we're talking about smaller companies, it's also about the 3 years. Well, what shall we do with the companies less than 100 with less than 100 employees? They can do this on a voluntary basis, but we don't know that yet. Local legislation, which means the Dutch legislation, can provide that also smaller companies will be obliged to file or submit such reports. And this can be, of course, of interest, especially for bigger foreign companies which have smaller entities established in the Netherlands. So for those companies, we'll keep you informed in the years to come.
What may be interesting for our international clients to understand is that this reporting obligation will apply for each member state separately. So for companies who have entities in several EU member states, they will have to do this report in every member state individually. So there is no possibility to make a combined report, unfortunately.
So what should be in the report? First, of course, we have each company has to investigate whether or not there is some sort of gender pay gap. And if there is a gender pay gap of more than 5%, meaning in general, men are paid better than women until now. So if that gap is more higher than 5%, it has to be reported. And it has to be reported if such a gap cannot be justified by objective gender-neutral criteria. And such report must be filed if there has not been a remedy. Because, of course, if you investigate and you find out that such a gap exists, the company has an obligation to restore such a gap. Well, and if you don't do that, then damages and also fines can be installed by the local authorities. But in the end, this is still to be put into legislation in the years to come. As said, it must be instated in 2026, and the first year of reporting will be 2027. So that is from now 3 years. So much for obligation on the equal pay. An environmental reporting issue is, of course, what we call the reporting obligation, work-related personal mobility. And this reporting obligation has come to life since what we call in the Netherlands the National Climate Agreement of 2019, already 5 years ago, I would say. And it means that if you have an organization with more than 100 or more than 100 employees, you will have to be able to report on your employees' business and commuting as from 1st of July 2024. This is a new date because this date was the 1st of March, I believe, and now it is postponed until the 1st of July. And the question is, what do you report? We're talking about travel kilometers. How many travel kilometers? And you have to report it per person. The mileage has to be separately for each type of transport and also for each type of fuel. So this requires administrative tools. And it also requires that you specify whether we're talking about commuting or business mobility. In the slides you can see that we've put in some guidance via the website of the rvo.nl. There you can find more information. And the third part I would like to talk to you when we're talking about ESG is the Dutch Corporate Governance Code, which was renewed already in December 2022, which is a little bit more than a year ago. The Dutch Corporate Governance Code is usually applicable to what we call listed companies, so you have to be listed at the stock exchange, but many companies use this code also to develop their own reporting guidelines towards the public. And it is all about comply or explain. So the code does not contain obligation that you have to follow. It just asks you to explain why you do not follow. Well, the Dutch Corporate Governance Code, as we have it, has been instated already since 2000, and during the time, more focus has come, especially lately, on what we call the sustainable long-term value creation for companies. And that means that we are talking now about more reporting about diversity and inclusion and about company culture. For example, when we talk about diversity and inclusion in the Corporate Governance Code, the code states explicitly that each company should have a D&I policy for the company, and this D&I policy should in any case get specific, appropriate and, read it out, ambitious target in order to achieve a good balance in gender diversity, and the other D&I aspects of relevance to the company. And it's not only about developing such a policy, it's also about reporting on such a D&I policy. So the corporate governance statement, which is of course in the annual accounts, should explain the D&I policy and the way in which it is implemented. And that means also, because of course we're talking about HR quarterly reviews, this is something that HR professionals should put on their agenda if it's not already there, because it will be subject to discussions also in the board and in the supervisory board. The same is about talking within the company and also implementing the values. The management board should adopt values for the company and its affiliated enterprise that contribute to a culture focused on sustainable long-term value creation, which is more than just adding value to the shareholders. That's also what all these ESG criteria are about. And that means existing culture should be focused on within the enterprise and whether it is desirable to implement any changes. And again, this is something for you as an HR professional to put on your agenda. The corporate governance codes, when we're talking about the D&I and also culture policies, is the employee participations. Because if you, within your company, have a works council established, the topics that I talked to you before are to be discussed in consultations between the management board, the supervisory board, and the works council. And we're talking about the conduct and the culture in the company and its affiliated companies, the values, and also the company's D&I policy. These should be put on the agenda in the supervisory board, but also in the meetings between the management, works council, and the supervisory board. And well, that brings me now to the next topic by Michelle about the 30% ruling and the developments there. Here you go.
So a lot of reporting obligations for employers coming up. In the meantime, I just wanted to quickly mention, because I did not do that at the beginning, that of course you have the opportunity to ask us questions if you have any, which I will see on this screen next to me, and we will try to answer them during the webinar. So please feel free to raise any questions if you have them. What I would like to talk to you about are some recent developments in the 30% tax ruling. For those of you who are not that familiar with this specific ruling, I will shortly explain what it is. The 30% tax ruling allows expert employees from abroad, under specific conditions, to make use of a tax-free allowance of up to 30% of their taxable salary. In short, this means that 30% of their gross salary each month is not taxed by the Dutch tax authorities. The reason we have this ruling in the Netherlands is that it is meant to make it more attractive for these expert employees to come to the Netherlands, and it is also intended to compensate them for their additional costs when they choose to move to the Netherlands. So the costs that they incur during their temporary stay here in the Netherlands, what we call the extraterritorial costs. How is this then done in practice? The term of this 30% tax ruling is a maximum of 5 years, and it also offers additional tax benefits, such as designating the employee as a foreign taxpayer for box 2 and box 3, and a tax-free allowance for an international school for the children. This is how it works up until now. And the recent developments that have taken place is that it will be further reduced. I say further because a few years ago, the duration of the 30% tax ruling was reduced from 8 years to 5. And we now have further reduction of this 30% tax ruling. This has been a topic of a lot of discussion over the past few months. These changes were announced, and for a while it was uncertain whether they would take place, since at the moment we do not officially have a new government. But despite that, the Dutch Senate voted on this on the 19th of December, and these changes have now been adopted and are also implemented as from the 1st of January this year. So what do these further reductions look like? Well, it has been determined that as of the 1st of January this year, the 30% ruling will only apply to a salary of currently a maximum of 233,000 euros gross per year, which is actually in line with the maximum salary under our Dutch Top Income Standards Act. So the 30% tax-free is applied to a maximum amount of 233,000 euros gross. Additional reductions that will take place will mean that the tax-free compensation is capped at different percentages during certain periods within those 5 years. So up until now, for the full 5 years, it was a benefit of 30% of the salary, which will now gradually be lowered depending on where you are in those 5 years. So to be specific, in the first 20 months, you can still apply 30% of the gross income. In the next 20 years, from 21 to 40 months, not years, that will be quite a lot. It's 20%, and in the last 20 months, it's 10%. So that has now changed. In addition to that, the other benefits are also limited. So the notional foreign tax liability will also be stopped as of the 1st of January. And as a result, this expat, the knowledge migrant, has to pay Dutch income tax on their substantial interest in assets as well. So in order to make it a little bit more easier for everyone to get used to these changes, there has been transitional law imposed. And that transitional law means that for employees who have already made use of the 30% tax ruling scheme for the last pay period of 2023, this transitional arrangement applies. And that means that the previously set restrictions remain in place, but the phasing out scheme does not yet apply. So for every employee who had 30% tax ruling in December 2023, they can keep those 30% for the full 5 years, and new employees will be confronted with the scheme I just mentioned with the different percentages.
So understand that managers with, let's say, an annual salary 400,000 euros in 2023, they will be imposed to a maximum of 233, but they will have the full 30% of the years left.
Correct.
Okay, yeah. Thank you.
So the other transitional law is with regard to the notional foreign tax liability. That will expire on the 31st of December 2026, after which there will be no longer an option to do that after 2027. But that is only for current employees who have the 30% tax ruling, who are allowed to keep this based on this transitional law. For new employees, the new rules will immediately apply. I have a question here that says, is this also applicable for expats who work from the Netherlands in Belgium? I'm not sure if that means that they are based in the Netherlands and sometimes go to Belgium, or if they were hired from the Netherlands and then went to Belgium. As I understand it, it only applies to employees who work in the Netherlands and are therefore eligible to the 30% tax ruling.
That's what it's about.
Yeah.
Yes.
So, of course, it is important for companies to check with their tax advisors how these changes implement the workforce, if anything needs to be arranged for current employees, but also for new hires. So if you did not do that, I would advise you to contact your tax advisor to see if anything needs to happen. From an employment law perspective, we think that there are quite some consequences for you as an employer. Among others, this means significant administrative costs for you as an employer, because you must monitor these changes in the percentage of the 30% tax scheme during the entire 5-year period to make sure that you lower it at the right time. And these changes may also lead to a more internal policy change and a choice to reimburse actual territorial costs instead of opting for the 30% ruling. Because of all the administrative burden that is now added to this, it might be easier or maybe even more beneficial to just compensate for the actual costs that were made instead of applying the 30% tax ruling. Now, I see that there was an addition to the question. It's an international employer and the person works for the Belgium entity as well as the Dutch entity. Well, we're not tax expert, but my first thought is that this 30% tax ruling can only be applied to the Dutch part of the salary, so only for the hours and the income that is performed in the Netherlands and not the part of the salary that is related to the activities in Belgium. But I would advise you to double check this with a tax advisor to make sure that this is correct. All right. To finalize this topic for now, these proposed changes will significantly increase the burden on employers. And like I said, the choice to reimburse actual costs may become more attractive than using the 30% tax ruling. But of course, employees currently in this labor market might still have a good negotiation position. And I think a lot of expats are well aware of this ruling that we have and might want to keep it or negotiate this when they come to work for you. But at least keep in mind that there have been quite some changes in this regard.
So that may lead to higher employer costs.
Maybe, yes. Yeah. So in relation to these changes in the 30% tax ruling, I would now like to discuss a recent Supreme Court case from the Netherlands, which also relates to changes in tax legislation and consequences for you as an employer. So the facts and circumstances of this case were as follows. It considered two Swiss airline pilots who claimed that their employer, KLM, has violated its obligations under good employment practices by not warning or informing them about a change in a tax treaty concluded between the Netherlands and Switzerland. This change in the tax treaty had possible financial consequences for the pilots. And as a result of the change, unlike before, these pilots now were liable to pay wage and income tax on the wages that KLM paid them. And they were then confronted with a significant additional income tax assessment for the year 2017 and 18. And as a consequence, the airline pilots now claim damages from their employer KLM. So this case was first assessed by our sub-district court, and the sub-district court judge partially granted the airline pilots' claims by saying that KLM was liable for 50% of the damages suffered by the pilots, therefore saying that it was actually a joint responsibility and then also a joint liability in relation to the damages as a consequence of these tax changes. The airline pilots were not very happy with that outcome and decided to appeal the case. And in that appeal case, the court dismissed their claims. According to the court, in short, the employee has their own responsibility for fulfilling their tax obligations and for taking note of the relevant information. According to the appeal court, KLM's duty of care as an employer does not extend so far that it has an advisory role on this point. So two different outcomes. The sub-district court says it's also the liability of KLM, and the appeal court said no, it's actually the full responsibility of just the employee. The airline pilots then take their case to the Supreme Court. And what the Supreme Court has ruled is the following. On the grounds of good employment practices, the employer may, under certain circumstances, be obliged to inform the employee of a change in regulations that is important for his financial position. Keep in mind the 30% tax ruling that we just discussed. So why did the Supreme Court rule this? The Supreme Court said that in principle it is true, like the court also said, that an employee is itself responsible for correct compliance with tax obligations, and that in principle the employer has no advisory role. However, as the Supreme Court continues, this does not change the fact that under certain circumstances the employer can be obligated on the basis of good employment practices to inform the employee of a change. Well, when do these certain circumstances apply? That is the case, in particular, if the information in question is equally important for the employer's obligation to withhold and pay payroll tax. So if the specific tax regulation that we're talking about also has obligations for the employer as well as the employee, then the employer cannot say, well, this is just the obligation of the employee. So in that situation, the employer is obliged to provide information to the employee on these upcoming changes. So the following circumstances in this case specifically were relevant. The first one being that KLM is a large professional employer with its own tax department and many employees living abroad. I think thereby saying that they were well aware of these tax changes. The second relevant circumstance was that the treaty change may mean that, unlike before, some employees would become liable for income tax, and KLM would have to withhold and pay payroll tax on the wages of these employees. So also a change for KLM as well. And finally, KLM was aware of the treaty change and should have been so. Based on these circumstances, the Supreme Court considers that KLM did have an obligation in light of these circumstances to inform the tax pilots of these changes. So this ruling of the Supreme Court has the following consequences for you as an employer. The first one, I think, already exists, meaning that you need to stay on top of changing tax regulations. This ruling in itself does not change that, but it becomes more and more important to be aware of any changes coming up. Mm-hmm. And when you meet the criteria of the Supreme Court ruling, you have an obligation to inform your employees of any changes. Mm-hmm. In my opinion, because the 30% tax ruling also means that as an employer, you need to change the wages and the taxes on those wages, the 30% tax ruling falls under this Supreme Court ruling, and therefore as an employer you have an obligation to inform your employees about these changes. Mm-hmm. So insofar you did not do that yet, please know that you are obliged to inform your employees of all changes in tax regulations, but specifically also the 30% tax ruling that we just discussed. Mm-hmm. And finally, the consequence could be that you risk a claim for damages if you do not meet the obligation to inform your employees of these changes.
Yeah, well, the Supreme Court also says, well, KLM is a large professional employer mm-hmm. with an own tax department. Do you think that that is of importance if you look at the criteria that you just mentioned, or would you say, well, the fact that you have this withholding tax obligation is enough to qualify for this information obligation? What do you think?
I think ultimately it will, because even if you are a very small company, you still need to withhold taxes on the salary of your employees. So maybe that would have an impact on how liable you are, maybe not the full 100%, but maybe mm-hmm. less, if you can show that for some reason you are not aware of these changes. But I think that even a small company will have to work with a tax advisor, making it likely that they will also be aware of these changes.
But tax should inform, finance should inform HR for this kind of stuff, because it is, again, HR who is mostly on the information side when we're talking about the company. I'm asking this because, of course, we know that amongst our viewers we have many bigger companies with a hub in the Netherlands.
Yeah.
So that's why I was wondering, is these are also professional companies, but only with a small representation here. Mm-hmm. So you would say it's also applicable to that part?
Yes, I would say so.
Okay.
Yeah. So we're giving our viewers a lot of work today.
Yes, we do.
So we move on to the next topic.
Yeah, thank you so much. I want to talk to you again. When you've been watching our webinars before, you know that Deliveroo sometimes comes up. You may have read about it in the newspaper. You may have read about Deliveroo in your own country when you're abroad, because Deliveroo and its riders, they're fighting all over Europe about the contractual status of these riders. Do these riders have an employment contract, or can they be considered an entrepreneur somehow? And of importance in the Deliveroo case has been the fact that the Deliveroo contract, and it's not only in the Netherlands the case, but for example in Belgium and also in Great Britain, is the fact that these riders can be replaced. So a rider gets a message, would you like to take this ride? Yes, I do. And then you ask someone else to do it for you. That's a possibility the contract provides for. But it also states that if you do so, such a alternative rider should also present a valid ID. And that is, of course, relevant, because you don't want, let's say, illegal persons to do the work. Deliveroo has somehow to check whether or not such a person who is replacing the regular rider, whether or not he's allowed to do so. And this fight has been going on for some time now. It has been to the sub-district court, it has been to the Court of Appeal, but in the end, this court case has come to an end in March 2023, and this is an important case for many sectors, because it is also about hiring contractors. We're actually talking about the question, is a person a contractor or is he an employee? And the question is, how are you going to determine that? And the Supreme Court in the end has said, we're going to use what we call the holistic approach, which means that if it sounds like an elephant and it smells like an elephant and somehow it looks like an elephant, it is probably an elephant. That's what we call the holistic approach. And so the Dutch Supreme Court has validated these contracts and has said, okay, when we look at the contract and also how the contract is executed, the following issues are relevant. And one of them, of course, the nature and the duration of the work, but also the manner in which the work and working hours are determined. Who is doing that? Is it something the contractor can do by itself, or is it something that, in this case, Deliveroo does? It's also about the embedding of the work and the person performing the work in the organization, which can be, of course, of interest also for companies who are hiring interim professionals to do work which is regularly done by an employee. And very important, whether or not there is an obligation to perform the work in person, which is, of course, this question, can I have myself replaced by someone else without interference from the company, from Deliveroo in this case? And of course, an important issue is, how was the contractual settlement made? How was it established? Was there an equal negotiation? Or is the employer at this level and the employee or contractor at this level? And of course, what's the salary like? And in the end, does this person, this contractor or employee, can it actually act as an entrepreneur itself? Does he have some commercial risk by taking on this job? Or is he an entrepreneur at all? And that is that's the other part, because you can see it, all these details, and then in the end, the court should look at the question, okay, so if you looked at all these aspects of the contract and the way it's executed, and then the court should ask, okay, but in the end, is this person an entrepreneur, or can he behave as an entrepreneur? in the course of trade or not. And if that is not the case, then such a contract will be considered an employment contract, which was also the case in this Deliveroo case. So all these riders who were actually given a contract, being a contractor, stating that they were able to replace themselves, giving them an administration, making sure that they were registered at the Dutch Chamber of Commerce. So the company was really trying to establish an administrative entrepreneurship for these people. The Supreme Court in the end said, I'm sorry, but from the holistic point of view, these people are not real entrepreneurs. So they are to be considered employees. And that means that these riders do have an employment contract. And the court says the freedom to be replaced, which is provided for in the contract, is not in itself incompatible with the existence of a contract of employment, and it therefore must be considered in the light of all circumstances. So this replacement issue should be considered in the total holistic approach. So even if you have in a contract the possibility that a contractor can replace himself by someone else, does not mean by itself that there is a contract. And it also led to a second case for Deliveroo, which is probably the final, because as we all know, Deliveroo left the Netherlands already. They have no activities here anymore. And because of the fact that these riders had this employment contract, the pension fund came in. The pension fund for professional goods transferred by road and mobile crane rental, which is an obligatory pension fund for everybody in the transport sector. And this sectoral pension fund said, well, if Deliveroo is to be considered a transport organization, then all its riders should be listed at our pension fund and pay premiums, which means that Deliveroo also was obliged to pay pension premiums retroactive for 5 years. And it also means that these riders can claim from these pension funds actual pension when they retire in full. So does this mean that Deliveroo has come to an end? Well, it may have come to an end in the Netherlands, and I will come back to this a little bit later when we're talking about legislation initiatives. But Deliveroo is fighting all across Europe about this. And let's say the UK Supreme Court, they came on in November 21st stating, sorry, this contract, which is about the same contract that they used in the Netherlands, is not an employment contract. Because in the UK, the Supreme Court considered this right to appoint a substitute, that's the British way of talking about replacement, they felt that the fact that you can appoint a substitute is such a fundamental difference to an employment contract that because of that it cannot be an employment contract. So we have the Supreme Court in the Netherlands, we have the Supreme Court in the UK, and then very recently Brussels came through, and then we're talking not about European legislation, but we're talking about the Brussels Labour Court of Appeal, a Belgian case, actually more or less following the line of the Dutch Supreme Court. So it is expected that also under Belgian law, these Deliveroo riders will be taken under the scope of an employment contract. We're all awaiting now specific European legislation on platform labor, and it is not unlikely that this issue will therefore be resolved on that level. But as we all know, the UK is not part of the European Union anymore, so they have their own reality. Which brings me now to some legislative developments which I will discuss with you in the end. And you can say actually nowadays that democracy in the Netherlands has gained a new element, because as we all know, laws are made in parliament, but before the laws come to Parliament, now we have this, what we call internet consultations, which means that everybody in the Netherlands can respond to the draft legislations which come to life, the ideas from the ministries. And these international then such an internet consultation comes in, which means that all parties involved, the unions, workers' organizations, but also professionals, they can respond on the quality and of course the consequences of such a legislative initiative. And one of these initiatives that was consulted on last year was the Act on Clarification of the Assessment of Employment Relations and Legal Presumption, which is a lot of words about how to determine whether or not a contract can be considered an employment contract or not. And this internet consultation actually easily said we're going to leave this what we call holistic approach because it's too difficult, it's too uncertain, and they want to replace it by a mathematic system with points, which means this issue has so many points and this is with a really tough formula. There has been a lot of criticism on that mathematic system. The internet consultation has closed. After it was closed, the Deliveroo Supreme Court came again, and so it is very much the question whether or not this specific act will be put on the agenda for Parliament, especially, well, not in the near future, as we have no government, as you all know at the moment. A second legislative development, also an internet consultation, is about what we call the Flexible Workforce Security Improvement Act. And that is more or less also, you could say, a little bit of an ESG development because it's about social, it is about getting more security on flex contracts. And the idea is that fixed-term contracts will be limited to 3, as it is now, but 0-hour contracts will be abolished, which means that you cannot offer a 0-hour contract anymore. And they want to improve the position of temp workers. Also been a lot of criticism on this internet consultation, but this Flexible Workforce Security Improvement Act may actually come to life, but that will be as soon as it's really into Parliament. We'll come back on that as well. And then the last internet consultation, which was finalized, is the bill to amend the reintegration obligations in the second year of illness for employees of small and medium-sized employers. They want to make that easier for these companies. And that brings me back to Michelle, who's talking you through holiday developments.
So before we go to this final topic of our webinar today, I would like to inform you that at the end of the webinar, we will provide you with a few poll questions, and these questions are related to your opinion on the webinar. So we would like to ask you to remain seated for a few more seconds after the presentation is finalized and help us improve our webinar by answering these 3 very short questions, and we would appreciate that very much. So the final topic for today that I wanted to talk to you about is some recent case law regarding holidays or annual leave, whatever you prefer to call it. And there are 2 topics we would like to bring to your attention. And the first one is related to the combination of sickness and taking holiday. So we have a regulation in our Dutch civil code that provides for rules when you can mark sick days as holidays. And there has been a Supreme Court ruling on this on the 17th of November. So the questions that were part of this court case were if the employer is allowed to write off employees' vacation days if the employee, after the vacation was already determined, becomes ill but still goes on vacation. And the other question that was talked about in this ruling is what is meant with the requirement of consent in order to write off these holidays. So what was the situation and the background of this case? It concerned an employee who was ill but has asked the company doctor of his employer, DAF Trucks BV, whether he can go on holiday. The holiday was already determined before the employee became ill. The company doctor agreed that it would be good for the employee to go on holiday, and so did the employee's manager. But the company then deducts 29 vacation days from the employee's vacation day balance. In this procedure, the employee says, no, this was not allowed, and I want those 29 vacation days back. It should be reversed, and these days should be paid out to me. And the employee based this claim on the fact that DAF acted in violation of Article 638, subparagraph 8 of our Dutch Civil Code. And the reason he does not agree is because he said, well, I was sick during my holiday and you did not get my consent to mark this as vacation days. So according to the employer, the employee did consent, and they also base their argument on the collective labor agreement, which would also allow them to deduct the vacation days. The sub-district court, so the first court to rule on this matter, says that the employee's claims were rejected on the grounds that the employee agreed to deduct the vacation days. The appeal court, however, again, as we saw earlier today, came to a different conclusion. The appeal court said that the employer was not allowed to write off the vacation days because the employee did not consent to this. And in addition, the court said that a collective labor agreement does not count as a written agreement. And then DAF, the employer, decided to appeal that case. And then it became a Supreme Court case. And the Supreme Court has ruled the following. The Supreme Court said that the specific regulation that we are talking about only concerns the settlement of vacation days in the event that the employee becomes ill before or during a vacation that was already determined before he became sick. So to be clear, this Supreme Court ruling only is related to the situation where an employee has already scheduled a vacation and then becomes ill. So this does not relate to the situation where an employee is ill and afterwards wants to take up a vacation. So it's only related to the other situation. The Supreme Court said that an employee in this case must explicitly and specifically agree to deduction of vacation days when he was sick and whenever the circumstance that gave rise to the absence occurs or has occurred. And to assume that consent that has to be given explicitly and specifically, it was not sufficient in this case that the sick employee informs the company doctor and his manager that he wants to go on holiday. So this is very important, I think, for our viewers in HR, that the fact that a sick employee mentions to the company doctor and his manager that he wants to go on holiday does not mean that he or she explicitly and specifically agrees to also deducting these vacation days. So this means that even though that it is clear for everyone involved that the employee wanted to go on holiday even though they were sick, it is still necessary to get an explicit and specific consent to also deduct vacation days. So I think in this specific case, it would have been better to send a short email to the employee saying, okay, you are going on holiday. Can you please confirm that we will deduct these days from your vacation balance? Mm-hmm. So quite a far-reaching obligation, I would say, because I think in these circumstances, it would have been reasonable to assume that the employee consents to this holiday, but in order to be able to deduct holidays from the balance, you need more explicit consent from the employee to do so.
So how do you think as an HR professional, what can you do to manage the managers who are just allowing their people to go on holiday?
I think, you need to find a workaround internally how you want to do that. So either you make an agreement with the managers that they always inform HR in case of a sick employee who wants to go on holiday, or you give them specific instructions to get an explicit consent from the employee to deduct the holidays.
So, or special form.
A special form.
Special
that
form
could also
ideal.
work. To fill in, definitely. But it is something to be aware of, because the consequence might be that the employee goes on holiday during his sickness and you're not able to deduct those days from their holiday balance.
Exactly. Yeah.
A question that comes up is if it is possible as an employer to refuse the holiday. No, that's not possible. It is already quite difficult to refuse the employee to take up holiday, and especially in this situation where the company doctor also confirmed that the employee was able to go on holiday, I think it would be very difficult, maybe even impossible, to say that you can refuse the holiday. So that would be a very sad situation for the employer, because the employee then did have a holiday, but you're not able to deduct the actual holidays from their balance.
So you cannot refuse a holiday because of the fact that the worker is not willing to have these days deducted as holidays.
Yes.
Interesting.
Yeah. All right. Then the final case law that I wanted to discuss with you is one from the European Court of Justice. And this relates to the situation where an employee was terminated, their employment contract was terminated, and afterwards reinstated. And then the question is how to deal with their holidays during the period in between, even if no work has been done. This has become relevant in the Netherlands as well. Since a few years now, we have the possibility also to appeal a termination of an employment contract. Hopefully in practice, this will not happen very often, but I'm going to walk you through it anyway. The facts and circumstances of this case were as follows. The employee joined the company in 2009 and was given notice of dismissal as of the 1st of January 2014. The judge in this situation ruled that the dismissal was unlawful and ordered that the company had to employ the employee again starting January 2017, so 3 years later. Then the employee received compensation for the salary that was missed in those 3 years in between. And shortly after the employee returned to employment, submitted an application to use the unused vacation days from those 3 years in between. And the employer rejected this request because the employee had not worked during that period. And now the question is whether this is allowed or not. So the European Court said that in principle, holidays are meant to establish or enable the worker to rest from the work that has been carried out. And therefore, the rights to paid annual leave are in principle calculated on the basis that the employee actually works, and therefore on the periods of actual work completed under the employment contract. But it should be noted, the European Court said that in certain situations where the worker is unable to perform their duties for the right to paid annual leave, it cannot be a condition that can be used to refuse those holidays. So that was the more general ruling, and specifically the court said that this means that the fact that the employee did not actually perform any work in the meantime, when there has been an unlawful dismissal and the re-employment is a result of the actions of the employer that led to the unlawful dismission, that without those actions, the employee would have been able to work and therefore exercise their right to annual leave. So the fact here that there was an unlawful dismissal makes it that the employee, even though they did not work during those 3 years, cannot be used to say that they don't have a right to their annual leave entitlement. So, therefore, the conclusion was that the period between the unlawful dismissal and the reinstatement of the worker, in accordance with national law, should be equated with a period of actual work for determining the rights to unpaid annual leave.
Wow.
Yeah.
Well,
hopefully, our Court of Appeal in the Netherlands won't take 3 years to reinstate the employment contract, but even if there, could easily be a year in between.
Mm-hmm.
And in that case, the employee remains entitled to their holidays for that year in between.
But it has a financial value.
Yes.
So, it's that's in that respect, it's an understandable decision, I would say.
Yeah, it is. I'm just quickly looking at one final question. I think we can do one before we close up.
Yeah.
Is an employee allowed to go on holiday without asking for permission to go on holiday? Because if he does, he can still enjoy the holiday even with the consent from the company doctor. And another question, does this mean that every employee can book a holiday, report sick, and then reclaim those holidays? Well, in order to answer the last question, no, because this Supreme Court ruling was not related to that situation. The situation was related to a holiday already booked and then reported sick. I think the most important thing is also still that the company doctor plays a role here and sees whether the employee is actually sick. And of course, this does not change the fact that the employee you can still ask for consent to book the holidays. But I do agree that somehow this makes it a little bit sensitive for fraud, I guess.
It does, especially when you report sick when you are on holiday. Then of course you have your regulations that somehow the company should be able to establish that situation, the sickness.
Yeah.
That's difficult, and especially when we've seen several cases, and it's the most difficult part is to establish whether or not this person is really ill, especially because they're not easy to reach sometimes.
Yeah. Well, I think that this is one of the topics in the Netherlands where the employee is entitled to quite a lot of protection.
Absolutely. Yep.
Yeah. All right. Well, thank you all for your attention and for joining our webinar today. I would like to quickly remind you again of the answers, the questions that follow shortly after we close up. And thank you for being here today, and we look forward to seeing you again with our next quarterly updates.
Thank you for joining.
Bye.